Welcome, everybody. I have a couple of announcements before we start the meeting. This meeting of the Pennsylvania Opioid Misuse and Addiction Abatement Trust Dispute Resolution Committee has been duly advertised as a public meeting in accordance with the Sunshine Act and is therefore open to members of the public as observers. Participation in the meeting, however, is limited to the presenting counties as beneficiaries under the trust order and their designated representatives, trustees on the DRC, and those that the trustees have invited in advance to take part. The meeting is being recorded, and minutes from this meeting will be available on the trust website after they are approved. An executive session was held immediately prior to the public meeting for the purpose of receiving legal updates and legal advice. With that, I'd like to move on to the agenda. First item is the approval of the minutes of the April 21st, 2025 DRC meeting. Could I have a motion to approve those minutes, please?
I'll make the motion. This is postal.
Okay, is there a second?
I'll second it. This is Timur Alexander.
Thank you, Tamar. Any discussion? Hearing none, the minutes are approved for the meeting. We have changed the agenda around slightly. The original agenda that was posted had us hearing Adams County and their appeal first, and Montgomery County second, and Chester County third. It does turn out that upon review of Montgomery County's submission to the DRC, it appears there were miscommunications as they relate to the reports for these programs. And if the board, in our opinion, had all the information we now have as a part of this appeal, these programs likely would have been approved by the full board at the June 5th, 2025 meeting as being compliant with Exhibit E. Do we have any representatives of Montgomery County present on the call?
Yes, Mr. Van Kirk, Lauren Hughes here for the County of Montgomery.
Hello, Lauren. How are you?
Good, and yourself?
Good, thank you. I wanted to make sure you were there because instead of requiring a presentation by Montgomery County, and I hope with your consent, the DRC would like to refer these two programs back to the full board so that it is the full board considering it instead of just the six of us that are present at this meeting. We would take the action at the August the 21st, 2025 public meeting with a recommendation from this group as opposed to the working group, a recommendation from this group that the programs be approved. Do we in fact have your consent to do it in that way?
You do. I have no objection to doing it that way.
Thank you, Lauren. Okay, with that, I would like to have a motion, make a motion, but I would have it be resolved that having reviewed the written information and submitted by Montgomery County to the Pennsylvania Opioid Trust Dispute Resolution Committee, the committee recommends that programs 31, which is PROACT reaching out, and 32, which was qualitative and quantitative chemical research on public health risk and harm reduction opportunities with illicit drug markets and material, that those two programs be referred to the full board of trustees for the trust to review and for further action. It is the recommendation of the DRC that these programs be approved by the full board as compliant with the requirements of Exhibit E to the National Opioid Settlements. Could I have a motion to that effect?
So move. This is postal.
Thank you, Rob. Is there a second?
Second.
Thank you. Any discussion on the motion? All those in favor, please say aye.
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 And opposed? Okay. I should have mentioned before that Bree, you had taken roll and let me know that all the members of the Dispute Resolution Committee are present, with the exception of Senator Tartaglione, who had a pre-existing commitment, but her representative is on the phone and able to add anything that he thinks the senator would want to add, although he is not a voting member. So we will move on to the appeal from Adams County. Are there Adams County representatives on the phone?
Yes, Mr. Van Kirk. My name is Lindsay Ringquist, and I am an assistant solicitor with Adams County.
Thank you, Lindsay. Anybody else?
No, it's just me today.
Okay.
All right. Well, thank you all very much for being willing to hear our appeal. We're very grateful for this opportunity to be able to present some additional information to you about remediation program number 3, or as we have called it, equipment to support recovery. We do recognize that our initial application was not as clear as it could have been in the connection between the program and supporting OUD recovery. So I wanted to start by explaining the 2 primary ways that we feel the purchase. Well, first, let me say that the program is to purchase a baler for the Adams Rescue Mission. They are a entity that they are a faith-based nonprofit entity. They have been in operation for about 50 years, and they support numerous populations in Adams County, primarily to get out of homeless situations. But they also are there to help individuals recover from addictive behaviors, primarily drugs and alcohol, although not limited to that. And part of that mission is that they have a recycling program. And the people who are in their program work that recycling facility, and they gain a lot from that experience. But something that is necessary for that recycling facility is a baler, so that they can prepare the materials, primarily cardboard and newspaper and things like that, for shipment out to recycling facilities. So they have asked for money to a portion of the total cost of the baler as the remediation program. So I wanted to explain how the purchase of the baler supports OUD recovery. And I think it does that in 2 primary ways. First of all, working with the baler provides valuable job training to the individuals in the recovery program, allowing them to leave ARM's program with marketable skills such as machine operation and machine maintenance, warehouse planning and organization, and soft skills like dispute resolution, and other things that you would gain from being in a work environment. Additionally, the income from the recycling operation, which the baler directly contributes to, is approximately $200,000 a year. And these funds are used to provide additional recovery services, including substance use and mental health counseling, mentoring and coaching, transition support, room and board, transportation, and medical care. So we feel that the purchase of the baler supports numerous approved uses under Exhibit E.
Lindsay, if I could just interrupt you for 1 minute.
Yes, absolutely.
If I could, I understand that the baler is no longer operable. Is that correct?
That is correct, yes.
And when did the baler go out of commission? When did it cease working?
It's my understanding that it was sometime in 2024.
Okay. And so you stopped receiving any of the funds that you were receiving from this, the recycling services that were provided ceased sometime in 2024.
I do believe that there are some of the recycling program that is able to continue. They also collect plastics and things like that. But it's my understanding that the cardboard, the newspaper, all of those things that they collect, they have not been able to do that.
Okay, thank you.
Yes. So yeah, we believe that the purchase of the baler supports numerous approved uses under Exhibit E. It helps to expand recovery services and the warm handoff programs. It helps provide comprehensive wraparound services to individuals with OUD, including job training, housing, and transportation. It broadens the scope of recovery services to include co-occurring substance use disorders and mental health conditions. ARM has the philosophy that they like to treat individuals through a holistic approach. And so in addition to helping individuals with opioid use disorder, they help with the co-occurring disorders. It addresses the needs of criminal justice involved persons. The Adams Rescue Mission is actually probably less than a mile from the Adams County Jail. And so a lot of individuals leaving incarceration will go directly to the mission to start their, re-entry into society. And then it engages a faith-based nonprofit organization to support people in treatment and recovery, and also to support outreach for treatment. And then the one final thing I would like to say is we want to reassure the trust that the funding request is proportional to the percentage of program participants who do suffer from OUD, which in 2024 was 48%. I will note that since then, they have been seeing increasing numbers of individuals in their program with OUD. Thus far in 2025, it has increased to 71.4%. But in 2024, which is when we are asking for this to apply to, it was 48%. So that's why the request for $225,469 was made, as that represents 48% of the total cost of the baler.
Okay, thank you.
Yes.
And thank you for a very, very thorough presentation. If I could ask, when the baler was out of service, where did how much revenue was lost that otherwise would have come into the Adams Rescue Mission? And to the extent that you know that, how was the money replaced? Did it come from other opioid funds or some other funds?
Unfortunately, I do not know exactly how much revenue was lost by ARM. But it's my understanding that they are hoping to apply for additional opioid funds, but they have not yet. The bulk of their revenue comes from the recycling program, which is still operational. They also have a flea market type area where they sell clothes and things like that. So they derive some revenue from that. And then they derive revenue from donations as well, which is how they're hoping to cover the remainder of the cost of the baler. They are hoping to secure approximately $50,000 in donations. And then they're hoping to enter into an agreement with Hanover to provide the remainder, which is, I believe, approximately $160,000.
Great, thank you.
Yes.
Do you know how large your budget is, the total budget of ARM?
I do not know how large the total budget of ARM is off the top of my head. No, I apologize.
I'm just wondering how they support the other support, the complementary counseling, and just the staff, just the supervisory people can't just let somebody go and run a baler.
Right. Yes. Yeah, no, they are very fortunate in the human resources that they have. A lot of their work is done through volunteers who assist. It's, as I said, it's a faith-based organization, and so they have a lot of people who volunteer to work with ARM, and then They participate in the Adams County Giving Spree every year. So they receive donations from that fundraiser. That's a really large fundraiser here in Adams County. But it's my understanding that the bulk of their mission is supported through donation.
Do you know how long they've been in existence with this program?
Yes, so ARM itself has been in existence for 50 years, and the recycling program that they use has been in existence for 40 of those years.
Okay.
Do you know if, sorry, Timur Alexander, do you know if they receive, how much funding do they receive from the county outside of this particular funding request?
They don't receive any funding from the county that I'm aware of.
Okay, thank you.
Yes.
Pam, you recognize the fact that you had a methodology to funding it by percentage of the OUD workers, the people that come in for the training and so on. I like that. How much of the 200,000 per year that you are expecting to generate, how much of that goes back into the OUD treatment program, funding, training program? Do you know that?
So all of that goes back into the general funding. So for 2024, we would say 48% would go back into OUD specifically. This year, about 71.4% would go towards individuals with OUD.
And a follow-up is, what other fundings? I know you mentioned another funding stream that they're hoping to get. What other funding streams are you looking at to fund the other half, or 52%? If you can reiterate that.
Yeah, absolutely. So they are hoping to run a donation campaign to procure, I believe it is, hold on, I have that exactly here, a fundraising campaign for $51,000. And then they are hoping to get a sub-grant partnership with Hanover Borough for the additional $127,000.
And what is the, you may or may not know this, and you said they've been doing this for 40 years. I don't know if that baler's been around for 40 years. Sometimes they have, I don't know.
It's been around for 20.
20. Okay. So if
Yes.
I were in my terminology, I think capital. So are they putting money back into the capital to repurchase another baler in 20 years? Is there a breakdown and continued maintenance and all those things that has to come off the top? Because I look for resiliency. I don't want to do it one time and then say, well, it's over, sort of how they got here, right? Like that's one of the things I always look at in these programs that they're putting back into their capital stock.
Sure. I don't know the answer. Yeah, I don't know the answer to that off the top of my head. However, I'm sure they would absolutely be willing to work towards that.
Thank you. That's all I have. Thank you.
Other questions?
Hi, you mentioned it helps out with the WHO programming. Can you explain that a little bit? The warm handoffs?
So yes, as I understand it, a lot of people come to ARM from, as I said, the prison or from getting out of inpatient, whether that's drug treatment, mental health treatment. So they come to ARM, and I will say the folks who work with the baler are from a men's home that ARM runs. They have 30 beds there that they support, but they also have a house called Agape House, which is more for families. And so it's my understanding that folks come either from homelessness or from incarceration or from inpatient treatment, and they are, connected to services. They're connected to just general resources, housing, transportation. They're given stipends, food. So that really helps to smooth that transition.
So someone is maybe from the single county authority or treatment provider or somewhere, someone is making sure those folks are getting, if they were inpatient, that they're getting hooked up with the next level of care that they're going to enter, or if they're from the jail, they're getting set up with outpatient community-based services?
Yes, that's my understanding, and that ARM helps with that process.
Thank you.
Yes.
Other questions of Lindsay?
No.
Okay, I will say we have typically not funded things like this, Lindsay, both because of the capital expenditure and it's it's a long reach to say that by the way, I think it's a great program. I admire the way the rescue mission utilizes people that they're helping in order to work the bailer, et cetera. At the same time, it really doesn't directly better the lives of those that we are responsible for overseeing the money for. So that's my only comment. It's just we haven't really. I can't think of another occasion where we've approved something like this. Jason, Jordan, Bree, you may want to correct me on that, but I can't think of one.
No, I can't either, but I do like the fact that it's revenue producing that goes back into the program, that is not totally reliant. I know that's a projection of 200,000. It's probably gross. I don't know what the net is, and that's not bad. If you're 200,000 from this program, it's quite a lot in a recycling program. But I like the fact, though, that again, it's not self-sustaining, but it is self-contributing over a long period of time. And
Right.
to be honest, guys, I mean, it is a very focused population that they're doing, and I'm sure ARM. That's why I asked about the budget, because there's a lot here. I mean, it's mentioned substance abuse, counseling, mentorship, coaching. You mentioned housing, transportation. I mean, there's a lot of programs that the rescue mission does. The budget has to be over $1 million. But anyway, that's kind of irrelevant to us. At first, my knee jerk with Tom was that a bailer, come on. But I dig into. They're certainly not extravagant, and I'm sure they're not using the money inappropriately. If we would vote to
Right.
That's my comment.
And I think your gut reaction was the same as mine, maybe others, that hey, a bailer, they've never seen anything like that. But I agree that both the material that was submitted plus the explanation that Lindsay has been giving is persuasive. Other comments?
Yeah, could I, I'm assuming that if they don't have the $200,000 in revenue from the bailer, that they're gonna have to cut programming or slots in the program. I mean, I would assume that would be one likely, or have to make up the money out in another way.
Yes, I think that is likely. And I know that they also are always trying to expand their programming. Their hope is to open a women's house at some point in the future without the additional revenue from the bailer. That might be a much more distant hope.
The one concern I do have is that it's not financed yet. And I hope, again, if we approve this, that the money doesn't just sit there while donations or contributions or fundraising. Good kudos to Hanover Borough for if they're able to get this. I mean, I don't know what their situation's like, but again, if this is approved, I don't know. Do we have I think we do have a date that money needs to be spent. It's 18 months. Would this fall under that? That the money needs to be put in, and so you need to totally finance this.
think it needs to be spent or committed to be spent.
Committed.
And with the commitment being a definitive commitment, not just a hope and a prayer, okay?
Right, right.
Has the trust,
Yes.
I'm relatively new to the trust, so some of these questions are from my colleagues here. Have we approved capital expenses for equipment like a heating system or something like that that would allow a program to continue functioning in the way that it had, or that would allow it to expand treatment slots by adding rooms or facility space that would allow them to increase revenue and service?
So I look at capital, Stuart, as there's a lot of people that invested in buildings. There's a lot of people that invested in buses, trauma care. It's all capital in my mind, as far as that goes. But yes, I would say yes.
And I concur that it is, yes, not, like a heating system specific, but yes, we've approved capital expenditures for expansion of facilities so that more people could be treated. Also so that more people could be counseled. We have provided we provided money when the expansion is to add additional rooms to provide more counseling space, et cetera. So the answer is yes, Stuart.
All right, thank you.
One final question before I make a recommendation, or a motion for the recommendation. The commissioners are ultimately responsible, and I know all three of them, and I know they're pretty active in these types of things. What is their response to this program, and are they in favor?
Yes, they are very supportive of this program.
Okay. And they believe it falls within Exhibit E.
Yes, they do.
Thank you.
Yes.
Okay. Other discussion? Okay, I'm going to ask for the following resolution, but I want to make clear when I ask, this is the same resolution that I ask after every appeal, okay? So it doesn't vary. I'm not trying to prejudge how anybody's vote is going to come out, because I know the way it is worded, sometimes it sounds like that. But the motion I would like to ask for is resolved that the Dispute Resolution Committee of the Pennsylvania Opioid Trust hereby affirms the decision of the Board of Trustees that Adams County Program Number 3, Equipment to Support Recovery, is not compliant with Exhibit E. A yes vote would maintain the current denial, whereas a no vote would reverse the decision by the trust that the program is not compliant. So if you're in favor of the money being spent on this, the appropriate vote from you is a no, okay?
Yes.
Can I have a motion to that effect, please?
So moved, Kevin Boozle.
Thank you, Kevin. Any other discussion that anybody wants to have?
You want to get a second, Tom?
Oh, I'm sorry, I thought I had one. Second,
Tamar
please.
Alexander, second.
Okay, thank you, Tamar. Okay, all those in favor, please say, all those voting yes, please say aye. Opposed?
No,
No,
No.
Okay, having heard a majority vote, the vote of this committee is no, and that reverses the decision by the trust. And Lindsay, the program, Adams County Program Number 3, Equipment to Support Recovery, is hereby approved.
Thank you all very much. We're very grateful.
Well, thank you very much for your presentation. As I said, it was very thorough and helped a lot in helping us reach the decision.
Thank you.
Excellent. I hope you all have a wonderful day.
Thank you, you too.
as well.
Okay, that will bring us to the second item on the agenda, the Chester County District Attorney Program Number 1. I do want to make sure that there are people representing Chester County present, because we did move ahead pretty quickly if they thought they were going to be at the end. So is there anybody present from the Chester County District Attorney who wants to make the presentation or is going to make the presentation regarding their program number 1.
Yes, good afternoon, Chair Van Kirk. My name is Kelsey Gavozdich. I'm an assistant solicitor here in Chester County, and we have on as well in other boxes, Chester County District Attorney Christopher DeBarenis-Roby, as well as the Honorable Anne Marie Wheatcraft, President Judge of the Chester County Court of Common Pleas, and also the administrator of all of Chester County's treatment courts. So if you'd like, I can proceed with my presentation. This program was submitted as Deputy District Attorney of Drug Court. We noted this in our written submission, but it can also be called Deputy District Attorney of Treatment Court. That aligns with the naming conventions where it used to be called Drug Court, but any references to Deputy DA Drug Court are interchangeable. I'm fully aware that a lot of the members on this trust are well-versed in treatment courts, so I will not belabor what is and is not a treatment court. But I did want to speak briefly about Chester County's 4 treatment courts. Here in Chester County, we have a drug court program, which began in 1997 and was the second program in Pennsylvania. And this program supports individuals with substance use disorders, many of whom have opioid use disorders or at high risk of developing opioid use disorders. We have a recovery court program that began in 2007, which is an intensive drug and alcohol treatment-based program, as well as a mental health court program, which began in 2008. That program is designed to address the needs of individuals with serious and persistent mental illness. And finally, we have our Veterans Court program, which began in 2010 and provides treatment and assistance to justice-involved veterans. Now, the best way we have to measure are these programs working, are they doing their job, is recidivism rates. For our drug court program, 87% of graduates measured between 2008 and 2025 had not been rearrested 2 years post-graduation. From 2010 to 2025 for recovery court, that number was 88%. From 2009 to 2025 for mental health court, it was 95%. And for Veterans Court, it was a little under 96%. Said differently, the recidivism rate for Chester County treatment court graduates over 15 plus years was between 4 to 13%. That can be compared with a 2016 study that looked at 7 Pennsylvania counties, which found that within 2 years of entering county supervision, 23% of individuals had been rearrested. This means that Chester County treatment courts on the low end create a 10% reduction in recidivism and at most almost a 19% reduction. But of course, the trust is most concerned with how does this comply with Exhibit E? If it does at all, that's what you're all tasked with ensuring. This was submitted under Schedule B, Section D3, which approves of programs or strategies that address the needs of persons with opioid use disorders and any co-occurring substance use disorders or mental health conditions who are involved in or at risk of becoming involved in the criminal justice system, including supporting treatment and recovery courts. Now, it was submitted under Section D3, but along with that, because the Deputy DA of Treatment Court position allows for faster eligibility reviews of treatment court participants, as well as faster admissions into treatment courts and collaboration with county and community partners providing treatment. It also enhances 17 other remediation programs, which we outlined in our written submission. Respectfully, by asserting a blanket prohibition on all law enforcement activities, or which involve a staff member of the district attorney's office, it's writing language into Exhibit E that contravenes the explicit language therein. There's no doubt that the trust is to ensure that opioid funds are consistent with Exhibit E. But Schedule B, Section D is directly aimed at addressing the needs of criminal justice involved persons, including those programs or strategies that support treatment and recovery courts. Rules of statutory interpretation teach us that if words are plain and free from ambiguity, then we rely on the plain language of the statute, or in this case of Exhibit E. If the drafters of it wanted to say any staff positions, anything touching on law enforcement, was prohibited, they would have presumably said so. But instead they did the opposite and directly included programs or strategies which address needs of criminally justice involved individuals. If this position was the deputy DA of the drug unit, which is tasked with prosecuting drug dealers or drug traffickers, there's no dispute that that would be an inappropriate use of opioid settlement funds. But that's not what this is. This is not law enforcement. This is treatment and diversion from the legal system. It should be noted too, which of course the trustees are well aware, that the term law enforcement does appear in reference 4 times in Exhibit E, and those are all of 2 allowable uses. Like, supporting medication-assisted treatment awareness and training for law enforcement, or support for law enforcement-assisted diversion models. So clearly Exhibit E contemplates that some opioid settlement funds would appropriately be allocated to law enforcement in specific circumstances. So saying across the board that a treatment court DA is not compliant with Exhibit E, it's not only a misunderstanding of what this position actually is, it's also out of line with the language of Exhibit E. And also, district attorneys' offices are rightfully recipients under the trust order, and they need to appropriately be able to spend funds on activities which, as was previously stated, assist the population that this trust is ensured that the money is appropriately being spent upon. District attorneys and treatment courts serve a much different purpose and role than those in criminal courts. These are problem-solving courts designed to provide alternative for individuals struggling with substance use disorders, opioid use disorder, mental health conditions. There was a time about pre-2010 when the treatment court DA in Chester County had to also carry a full trial schedule in addition to their treatment court duties. And there was grant funding received, and that allowed for review. Prior to that time, reviews for individuals to enter treatment court were slow, which caused delays in individuals getting into treatment. This is contrary to key component number 3 of drug treatment courts, which is that eligible participants are to be identified early and promptly and placed into the program. Getting individuals into treatment court is essential, as increases the likelihood that people are going to participate in these voluntary programs. We can't force anybody to do this, and increases the likelihood of success. Without opioid settlement funds, without this funding, it's likely that the assigned DA would have to revert back to taking on a full trial caseload in addition to these duties. This will delay individuals in being assessed and getting into treatment courts. And possibly,
Kelsey, if I could ask, before the
of course, Chair.
Before the opioid settlement was reached, and
Yes.
these courts were begun in 2006, 2010, depending which one was this position there, and was it funded by the county and or the county DA's office?
Yes, and I'll allow the DA or her honor to correct me if I'm wrong, but prior to that time, prior to getting the grant funding, it was just a county funded position, which is why the person had to also have normal responsibilities like a trial list.
Okay, and it was county funded because of the duty of the counties to make sure that the DA's office is fully funded. Is that correct?
Yes, presumably correct.
Okay.
And during that time, to your point, it was a slower admission process, and people weren't getting connected to treatment early, which people are less likely to want to participate in these programs, and they're also more likely to continue using, which means additional criminal charges and possibly overdoses. And
does a separate DA, Kelsey, if somebody decides not to voluntarily continue, or if they have breached the terms and have fallen off the wagon, if you will, is it the DA that you're seeking the funding for that seeks to incarcerate them eventually?
No, sir. It would be the person who fills this role never is the one prosecuting. If somebody for whatever circumstances, is removed from their treatment court, they would go into another court, another DA, and the information learned, other than the reasons for their withdrawal from treatment court, are not made available because people are sharing their trials and tribulations. And this person has a lot of that information because they're part of the treatment team. That's not shared, that if, you know, the person later has to go on into the regular criminal court system and be prosecuted.
Thank you.
And Chair, just to be clear, they do participate in a decision with the rest of the treatment court team, including Judge Wheatcraft, about whether they should stay in the program or not to protect the integrity of the program. So that part of the decision is a part of the treatment court team that Judge Wheatcraft's on the line for, and she can speak to that in more detail if you have questions about that. But the driving force behind that decision is, does that protect the treatment court system? And what does this person need? Do we think we have resources to be able to correct the behavior and keep them on a path forward?
Okay.
And I think that's a good point to turn it over to Judge Wheatcraft, who can speak much better about the treatment court programs here in Chester County and her experience. And then I'm sure District Attorney Deborah Nasarobi will also have some comments as well, and any questions we can answer.
Okay, Your Honor, do you want to proceed?
You're unmuted, but your microphone's not picking up, Judge.
No, we can't hear you, Your Honor.
Bree, is there perhaps a call-in number she can reach?
I can talk for a few minutes, and just to reiterate something, I did review the trust video of when it was rejected. Like this, I understand that it's a district attorney position, but this is not an enforcement position. This is a diversion position. This is someone who seeks out, works through the applications, connects people with treatment. This is someone who pulls other cases, maybe people who didn't apply, and into the program and notices them or hears about them in the office, and then tries to get them into treatment. These are people that we don't want to go through the criminal justice system. Look, I've been a drug prosecutor for my entire career, and I know that we can't do what we need to do as a society without real treatment, and I'm really committed to it. I've met too many people in my career who were going to be cooperators, who didn't want to get any treatment, that wanted to make sure that they could set up a drug dealer or two and move on, and get back to their use. And that's not the dynamic we want to have here in Chester County, because we see those people over and over and over again.
And I
really...
appreciate that. Could you explain one other thing to me, though? Why it seems more that the person is acting as a social worker to help people and facilitate their treatment, and why does it have to be, and that can be part of the DA's office, it doesn't, and funded by the DA's office, but why does it have to be a practicing attorney who also does prosecute people?
Well, this person doesn't prosecute people, so let's be clear on that. But I need someone with seasoning, someone with experience, someone to know, okay, this person who says that they want treatment is really part of the problem and a high-level drug dealer, and needs to be with a criminal history that shows that, and facts that show that, and therefore they shouldn't be in the treatment court program, because they're going to jeopardize the treatment court program by putting them in there. So I need someone who has real experience to know, okay, these types of cases, we need to get them into treatment right away. And these are the cases that actually need to end up in the criminal justice system. So it takes a specific level of experience. You cannot just hire a social worker off the street because they don't have the legal background to appreciate the risks on the back end. And that's why we've always placed someone with experience in this position in the office.
What is the training and the experience that's required for this position then? I'm not clear about that. Law school or what else?
So, I mean, and Judge Vicar can talk a little bit about it because she invented the position. She was previously, she was the first treatment court DA in Chester County. But there's a certain amount of learn as you go, but you have to have worked cases for, years to be able to do that. I'm not putting someone out of law school in this position. They don't.
Understood. I'm just wondering, is there any additional training that this person has that would be relevant to understanding?
We have them
Substance-
understand how the programs work, right? To partner with and to learn from our partners, some of which are on this call, like the Drug and Alcohol Department in Chester County, from other treatment providers, to get education on on treatment, such as how to treat opioids, right? To understand the studies that show that people need treatment more than once because they're exceedingly likely to fail 5-6 times before treatment takes. So we have, because we've only had 3 of these, 3 ADAs, I think, in this position over decades. We don't have like a fixed training program because I want to keep the same person in this spot year after year. Judge, I don't know if you're able to catch on, or maybe you dropped off trying to reboot, but it really is not, it's really about saying this isn't a retail theft. This is, and I don't care whether the person has a felony level retail theft because they qualify because they did 7 or more retail thefts or 5 or more retail thefts under the statute. This is a $200 theft from Rite Aid for razor blades. And we all know what that's doing, that they're reselling them on the secondary market that we see, and they're using that to go buy drugs, right? And we're going to get this person into drug treatment, and we're going to get them assessed. That's what this position is. And so it has really nothing to do with making offers other than offers to get into drug treatment.
But at the outset, this is the person that makes the decision whether the person goes into treatment through one of the treatment courts or is going to be prosecuted. Is that correct? They make
They make the decision
Yes.
with the treatment court, with the rest of the team in treatment court, right? So they get the perspectives of adult probation, of the judge, of the treatment providers, and they build those relationships with the providers in particular and review those reports.
Understood. Okay, thank you.
And then the work is with the provider to assure that that the person is complying with the participant handbook, or the participant agreement. So what the DA does, what this position does, is to assure that they are getting the person is getting the counseling, the support from other providers, because the court's not providing, they are referring. Is that the way this works?
Right. There are county approved treatment providers that are set up through a variety of fundings, and I see funding sources that are both state and federal, but we don't let people choose their provider, right? Because that also leads to bad outcomes. People get providers that are particularly lenient. They have to go through our county providers. They have to sign waivers so that their treatment progress is reported back. That treatment progress is customized by Judge Wheatcraft, the prosecutor, the public defender who sits in the room for all of these as well, and the rest of the treatment providers. And they come in person every day to make sure that they're dealing with stress. We give compliments and we celebrate successes in these programs because for the first time for some of these people, they're being celebrated for staying on task and accomplishing a goal.
Okay, well, I have one other question. Again, it's postal. I was looking for a percentage, the 52,000 and change. That's not the total. What percentage of that is the budget for this position?
I'd have to
salary for this position.
Yeah, I'd have to double check. I know since I took office in 2024, we have it, I believe, at 80%. I don't know what it was in this because the timeframes are mushy in my mind, but we tried to keep it at 80% because there is some sort of on-call duties that come up sometimes or other activities that come up. But this is Bonnie's her name. This is Bonnie's day in, day out job. She spends over 40 hours a week doing this.
Yeah, there must be other funds, obviously. It's not.
And I believe to jump in, that since this period we're talking about is July 1st, 2024 through December 31st, that 52,000 number comes from, at that time, it was her entire, half of her entire yearly salary.
Okay,
That was,
all
and then
right.
it changed to the 80/20. That is my understanding from speaking with the district attorney's numbers people.
Okay, that makes more sense because it was said that there's no prosecution. This position is not a prosecutor.
Correct.
Okay.
If I may ask a question, I think Christopher, before the judge speaks, I think you alluded you came in 2024. Your levy program was instituted in 2022, is that correct?
Yes, sir.
And how does Bonnie relate with the levy program at all? Does she help with law enforcement to divert people? I'm just trying to get a feel for what her whole role is.
She runs the Letty program as well.
That's what I was looking for. I wanted to know. Thank you.
Yeah, no. And actually we just got off a call an hour ago at 1 o'clock to try and, our goal is to boost our Letty program numbers. We're trying to figure out someone who can go train every police officer, the 1,200 police officers in the county who seem resistant to using the program, as I'm sure you all have seen as well, right? To make it, to beat back the stigma or the mindset, I guess is probably the better way of doing it. But we're trying to figure out a way where we can do that and use the money appropriately for a 1-year basis to just roll someone through a shift change and make them see someone in a room, because we know they're not going to open up the email.
Thank you.
And I believe Judge Wheatcraft is on the phone now.
Your Honor, are you on?
She is, her phone line is muted if someone can unmute that, but I don't know who's running the call.
Free, is it on our end?
How about
You're
now?
free, Judge.
Can you hear me
Oh, we
now?
got this.
You can hear me
Yes.
now?
Yes.
Yay! All right. Sorry about my technical difficulties. I am a little bit of a dinosaur. I was involved in drug court back in when it first got started in the early 2000s. And back then we did have just a drug court, and I was a full-time prosecutor and did treatment court on the side. But our programs have expanded so much now, where we have post-conviction, pre-sentence, veterans court, mental health court. Our program has expanded so much that is why at this point it really does need a dedicated position in the district attorney's office, because that is the gateway to our treatment courts, and that is by far the best way that we can help people who are criminally involved or criminally justice involved, who have substance use disorder. And I'm just such a huge proponent, and I feel very strongly about this, that this position is not a law enforcement position, because this is someone who gets to know the people who are involved. This is someone who becomes an advocate for the people who are involved. And to classify it as a law enforcement position is unfair to their part of the program, their role in the program. And I referenced in the letter that I wrote, All Rise, and I don't know if you all know what that is. That is the national organization of treatment courts. And part of their best practices is having a district attorney member involved on the treatment court team, because that is what makes treatment courts successful. And if we were to lose that position, or the ability for somebody to do this work full time, our programs would be greatly hindered, and we would have so much less ability to get people into the programs at all, and certainly the delay would be tremendous. When I did it, I was able to do it because we did have just one drug court, which was, not huge at the time. It was brand new. But now it truly is a full-time job, and it is truly designed to help people and to help those with substance use disorder. So it is an absolutely appropriate use of the funds that are intended to help people with substance use disorder, because this is the best way we can help people who get arrested. Do you have any questions for me specifically? I think that there was one that I missed when I couldn't get on.
Your Honor, if I may, this is Commissioner Kevin Boozle, Butler County. And first of all, I commend you for taking this on in an early drug court. It's been hugely successful in our county as well. I think that and I don't want to speak for my other trust members, but one of the issues that we've had is many people try to use funding for prosecution and, law enforcement and those types of things. I believe what you're describing is and we've talked about this even amongst the trust members, is you're talking about an advocate. I don't know if there's a name. This name thing is the problem. I'll be honest with you, because I'm afraid that other entities will read this and say, oh, well, they got a district attorney paid for, right? That's how they see it. And then we have to go back through and have to re-educate. It would be, to me, within reason to have a deputy district attorney drug court advocate 100% non-prosecutory in the name of it, because now we basically said this is somebody with a legal background, but also has the legal expertise to understand how the system operates so that I can help advocate and guide them through that system. I think that's what you're trying to do. You have to understand from our point of view where our hesitation is on this. And I only say that because if that's a qualifying statement that we can add and you're okay with that, or as a county, you're okay with that, I just need to know where you're at with that for us moving forward.
I mean,
So I think that's more of, I was going to say it's more of a question for Chris. Go ahead.
Yeah, I think if you want to change the title, that's fine, because they're not prosecuting people, right? I mean, they're diverting people. So if you want to call it a diversion court district attorney, if you want to call it a drug diversion court district attorney, however with non-prosecutor, the time that is allocated is not prosecution based for us. It's about getting people out of the system and getting them into treatment, or getting them into treatment with basically we have another program that you plead guilty, but if you complete treatment, your charges are dropped, right? And you don't go to sentencing, right? So we're in the spot, and Bonnie is in charge of that, because there are some times where I think people need that extra carrot stick approach in order to have treatment really be successful. So she's not prosecuting people, but if they get to go to sentencing, they're going to sentencing with someone else. They're not going with her. And in fact, our program for that says you can't actually hold treatment court failure against them at sentencing from the DA's spot, because I want people to be incentivized to go into treatment court. And all that says, change the title. We can call whatever you'd like. I just would like to approve it, because any DA in any county that is doing treatment court work deserves to have their spot, that portion of time, funded by the trust. It is critical work, and we need more treatment courts in the Commonwealth, period.
Agreed. I appreciate it.
And you do have you do have the All Rise behind you as well. You have the fact that All Rise, a national organization, recommends a district attorney team member on the treatment courts, and they're just a huge part of the success of treatment courts.
Can I ask a question? So I think you said that this position would sort of be the gatekeeper of getting that application to the committee. Is that correct?
So I guess the defense attorneys, but she's the gatekeeper to saying, yes, these are the tracks I would consider them for, or this person should not be in the treatment court, and they go to the prosecution side.
And so how, I guess, is that person making that decision on their own? They're making a decision whether or not someone is appropriate for treatment court, and based on.
Go ahead, Judge.
So, and there's a distinction to be made. So we have different tracks for treatment court. So we have the diversionary track, and under the law, only the district attorney can make that determination, simply like ARD. They're the only ones that can make the determination that charges will be withdrawn if they successfully complete the program. If the district attorney has somebody who applies for a post-conviction sentence in recovery court, and the district attorney says, I'm not going to agree to that, the judge does have an opportunity, I have an opportunity to say, I want to give this person a shot. I understand, your reasons for not approving this person for this lesser sentence. I want to give the person a shot. So that at times is my call. But when it comes to diversion, pure diversion, it's the district attorney's call. And also if they want to make an agreement with somebody that they're going to enter a guilty plea, but if they successfully complete the program, they can change or withdraw their plea at the end. So it's tricky just because we have so many different ways that we have expanded this program to make it to capture more people who we would otherwise miss. We used to miss the people in the middle who didn't qualify for recovery court because they weren't serious enough offenders and they weren't eligible for diversion. Now we were getting these people who have maybe a second offense or maybe have some priors with other offenses, but now have a second offense DUI. They're not eligible to be diverted and have their charges dismissed, but if they successfully complete it, they can plead to a much lesser charge.
I guess I'm still not entirely sure how I'm sorry, did you say the name was Bonnie?
Yes.
I'm not sure what we're calling this at this point. How, if she has an application in front of her, how she's making that determination, whether or not the case should proceed toward diversion. And I ask you this because I've done treatment court since 1998 and I've had many arguments with district attorneys over the years who tell me, client A is a drug dealer. And then I'm over here, well, client A is maybe dealing, but dealing to feed his family. So again, I know you said it's a slippery slope, it's a very thin line, but that's from my experience, that's where my concern comes from. And what if the staff changes?
So
Then what
that is just the perfect example. Like, so I set the policy. So if the staff changes, like, yes, I'll have to train my staff in how I want them to administer the program, right? But with Judge Wheatcraft's partnership, we've expanded the program to capture the exact person you want. In fact, the first person we put onto this program was traditionally someone charged with felony drug dealing did not qualify for drug court under the written parameters of the program. But I know, and Judge Wheatcraft knows, and you know, that there's a difference between someone selling a couple bundles of heroin on the side to make money so they can buy bundles of heroin from themselves, and someone who's selling raw heroin in ounce and multi-ounce forms, right? And so our first person was a very low-level drug dealer who sold an incredibly small amount of drugs to an undercover police officer with a prior misdemeanor. And we didn't have a mechanism to put them on because I think past administrations had been somewhat conservative in their approach. And we expanded it. We fit it under the statutory framework. That person doesn't qualify to have their arrest expunged, but they're going to have if they complete the program, and they're doing really well, I think, for last I heard, they're going to get another misdemeanor conviction, and they're not going to get a felony, and they're not going to have to be on probation because they've done the program for the last 12 to 18 months. That's what we've designed here. And I need someone who knows the difference between a drug dealer and a drug dealer who's selling drugs to feed their habit. Someone with that level of experience to sift through it. Because if you just go off the charges, you're gonna miss people. You just are. And I'd want someone who brings a level of nuance and appreciation to every case, who is not just gonna follow black and white rules. I've told Bonnie to be creative, and if she has someone on the margins, to bring them to me, and we'll figure out a way to get them in.
Okay. Thank you.
Is it possible for you to rename this position so that it does not include DA or prosecutor in the title, and make it clear that they do not have prosecutorial discretion? And it's important to us because of the number of requests we get from everybody. And unfortunately, not every county nor DA comes at it with the perspective that you are. And unless we have a clear definition that that DA or prosecutor is not in the title and that they don't have prosecutorial decision, we're opening ourselves up to 66 other counties coming in and that don't have the same diligence as you do.
Look, I'm happy to work with any one of you offline really quickly to rename it in a way that I think is truthful and consistent for the public. And I'm confident we could reach an agreement on the name that would approach like reach both of our goals. I can't think of one off the top of my head, but if you if I could work with someone for 15 minutes on it, I bet you we would come up with something.
And if I could suggest something, I'm just looking at some of the letters, the support letters, here's something. Not a traditional prosecutorial role. I mean, that comes up a lot. Perhaps, I don't know if it's in the judge's letter, it's in the probation, the probation chief letter. And there's other places too. I think that is a key. That was brought up earlier, maybe by Tom, that this is not a prosecutorial role, that the prosecution then would be handed off to somebody else. Let's take some phraseology out of what you already presented.
Do you have a treatment court coordinator?
We do.
I guess
We have two.
Yeah, just they're in other departments, I believe, right, Judge?
Adult probation. Yeah.
By the way, don't we support that? Barry, do you remember?
I don't remember.
Yeah.
I thought that we approved that, but anyway, that's irrelevant.
You might have approved at the same meeting, the treatment court administrator, which is a member of the DA's office, was approved.
Okay, that's the one that.
Okay, other questions? I'm sorry, Your Honor, I don't have more questions for you. It's nice to be in a position of being able to ask a judge a question instead of having to answer ones that you fire at me.
I can, if you think of any later, feel free to give me a call back.
Okay, I would appreciate that. Because you raised the question, Christopher, that you are willing to change, I would like to, if there's no other questions, I'd like to have an executive session with counsel who I would delegate to be working on exactly how the title is going to be and what limitations are going to be put on it, which I'm sure also, Christopher, can be worked out. But I would like to have executive session for 5 minutes and then we'll get back on the public meeting. Is that okay?
Sounds good.
Sounds good.
Okay, I'm going to get off of this meeting and dial for the executive session. Thank you. Thank you for indulging us with the executive decision. Obviously, this is not an easy decision based upon past precedent. The way you're describing it, obviously Your Honor's input into this. Christopher, I'd like to go back to the question that we were asking toward the end, and that is, are you willing to work with our attorneys in working not just on a job title, but on a job description that fully sets forth exactly what you are doing with this position and that it does not have prosecutorial discretion? And if you are willing to work with them on that, we would delay our vote on affirming or denying until we see if that can be worked out. But otherwise, we would proceed to a vote otherwise.
Yeah, I'm willing to work with everybody on whatever assurances you need to make sure that that's done. But the only discretion that is being executed prosecutorial is whether to enter or to be denied a diversion program.
And am I correct? Is that being done in conjunction with other people, not just this person?
Often, not always. Often, if someone applies who's been charged with murder, she's going to deny them and probably not talk to the judge about it, right? But yeah.
Okay, so you don't operate like we're operating at the federal level.
As a former federal prosecutor, I
Chris,
can only tell you how many layers of review there are to doing all of this stuff.
And part of the question, Chris, I'll be quite frank with you, is yes, you're the district attorney now. What about 4 years from now, 5 years from now? 10 years from now. So we want to work on what this description really is. If you're willing to do it, are you willing to give us until the time of the public meeting, which is August the 20th? And that will give you and our council a chance to work it out. This group will be reconvening at the time of the at the public meeting, and we can give you a final answer then. But can you work on the job description and be willing to consent to that?
Yes, of course. Yes, of course.
Okay. Other members of the committee?
Fine with that, Mr. Chairman.
Yeah, it's fine, Postal.
Anybody else? Council?
Tom, we'll be happy to work with the district attorney's office on
Yeah.
both the title and the substantive job description.
Yeah, and I want you to know that our final decision is going to depend upon what you all come up with. We're not promising any particular recommendation that we're going to be making. I want to be clear on that, but that will give us the additional time, give you a chance to work with council, Christopher, and let's see what comes out of it. Okay.
Sounds good.
Okay. Anything else for the good of this order?
I just want to say thank you to Chester County. I know they blazed a path early on with this. I think that they're on the right path now, and I think that you understand our circumstance. So I appreciate your honor and the DA and all of those involved, the assistant and so on. But I think that we've got to make sure we get this right, because it has major consequences long term if we make a poor decision up front. So we appreciate your patience. Thank you.
I agree. Thank you.
And I echo that. Thank you. Anything else? Okay. Thank you all very much for attending.